Dear students, let us start the discussion on today's newspaper, that is 12th May 2012. Hope all of you are out of this results frenziness. Now, think like this. If you are successful, it is good in one way, because you are entering into the next step of the life. If you are unable to clear this exam, don't think that this is the end of the road. There are many other ways you can be successful in life, and this examination do not define something called as success or failure. It is just an exam. Remember that point. So an exam on which students write, few businesses happen, an exam on which some merit is being assessed. Now understand, I am using the word some merit. Merit is a value. So, by the standards of UPSC, if you take Srinivas Ramanujan, he will never clear the UPSC because he is more focused. This examination, if he is not able to test or judge your merit, it means you are not as meritorious as this exam is expecting. It means it needs a different style of merit. Now, you are scientifically strong, you are a research-oriented guy. I will say that this exam is not for you, don't worry about this. You have a much better life ahead and just move on. So, however, let us start our class. The first one is related to the recent amendment to the double taxation avoidance agreement with the Mauritius. Now, let's take India and a Mauritius company. Mauritius, these two countries have an agreement, that is DTAA. So, if a good or a service or certain capital which is taxed in the Mauritius shall not be taxed in India. Now, Mauritius is a tax haven. So, if I show my capital or if I show my benefit or profit as part of the Mauritius, then what I believe is that will not be taxed, so that I will be benefited from it. Now, coming to India, if you take over here, what is happening is any investor, for example, an American investor or some other country where we do not have a DTAA, is taking the Mauritius route rather than coming directly to India to invest in Indian companies. So it means that India is losing a huge revenue out of it. And second, the other bleeding is this: even the Indian citizens, they are routing their investments through Mauritius. It means their money will go to the Mauritius through certain shell company. They will try to route the money back into India so that the money or the gains made out of that capital will not be taxed in India. So to curb these two things, an amendment is brought in. So under this amendment, the capital which has been gained, for example, if I brought some shares over here, some shares in a company over here, I am selling them less than 1 year, then automatically I have to pay the short-term gains tax. So in the short-term gains tax, if I made some 100 crores in India, so I have to pay some 15% to the government out of it. But as of now, with the existing provisions, if I pay the gains tax in capital gains tax in Mauritius, I need not pay the same tax in India. So this is a situation it is going to correct. Now you have to pay the capital gains tax in India irrespective of your payments in Mauritius. And the second thing over here, now this is not going to be immediately affected. So from 2019 onwards it is going to come into effect. From 2017 to 2019 we do not have such a situation. So from 2017 to 2019, the situation, there will be an exemption to pay half the tax of the total capital gains for these beneficiaries. So now there is another thing over here, that is Singapore. Now with regard to Singapore, the agreement is linked to the Mauritius agreement. It means if Mauritius double taxation avoidance agreement, if it is changed, automatically the Singapore DTAA is also bound to change. And Indian government has already started discussions on that particular front. And the third thing is the P notes. What are these P notes? Now let us take the stock exchange of India. In this stock exchange, the foreign institutional investors are investing. Now there is an investor from any other country, we don't know his identity. he will give this money to this institution, and this institution is investing it in India. So in return, this institution will give a P notes, participatory notes to this investor. So this FII knows about the investor, but the stock exchanges, the regulators of India are not knowing about the investors. So in this context, it is leading to greater volatility in Indian markets. But existing double taxation avoidance agreement is not clear, or it is not touching these P notes, declaration of the P notes under Know Your Client norms, KYC norms. And the government has to give more clarity on that particular issue. So again, there is another thing called general anti-avoidance rules. What does this mean? They are going to be implemented from 2017 onwards. As per this, anything or any arrangement between two businesses, two individuals can be questioned by the government. It is on part of the individual or the business to prove that the arrangement is not to evade the tax. So no, that arrangement is not about evading or avoiding the taxation. So the benefit of doubt do not apply over here, and the burden of proof lies on the individual rather than on the tax department. So this is what are the situations which are going to change from 2017, and it can be seen as a very good step towards curtailing the black money. So today 3 articles in Hindu and Indian Express, they discussed about it. So if you take the next article, explained page, in Indian Express, it is also same about that. Closing the tax bolt hole in in Hindu is also about this. Now let's get into the Tina. You know, this is very related to our field. Miss Tina, she got the All India rank 1. So there are certain positive developments to the results this year. Miss Tina, she is from a Dalit community, and at very young age of 22 years, she is able to clear the examination. So that shows a symbol that has a great symbolic value, where the Dalits getting selected to this prestigious examination through open category, that's also topping in the examination, is itself is a very positive sign. So that shows the work which we did throughout from the independence is really working. So on the other side, it also shows another thing. Her parents are engineers, and most of the people who are getting benefited from the existing societal, economic or political structure are some empowered Dalits. They are getting the benefits, and millions of the people are deprived of the same benefits. And coming to the second ranker, he is from Jammu and Kashmir. Recently, the dissent of the Kashmiris, especially youth, is increasing against India. So this rank, Faisal rank previously, Shah Faisal, now this rank, these are going to develop new hopes into the Kashmiri youth with regard to aspire for the better, greater positions in the Indian government. So from this perspective, we need to see the results. Now coming to the next article, the tale of two judgments. Now, if you take Article 21 of the Constitution, what are the words which are used? One is life, the second one is personal liberty, the third one is procedure established by law. Later, the Supreme Court has stated the substantive due process of the law is also part of the Article 21 of the Constitution. So, this substantive due process in the Menaka Gandhi case, it was given life. It was taken from the United States Constitution. So United States of America, the 5th and 14th Amendment Acts clearly give life to the due process of law. So in the procedure established by law, we don't question the merit of the legislature. So the factual part, or is the procedure is followed or not, that is what we are going to verify. Here we are also questioning the value of the merit of the legislature or law passed by the legislature. So in this case, with regard to the due process of the law, Indian Constitution has evolved over a period of time under Article 21. Because the Supreme Court has given different interpretations to the different aspects of the life. The right to life includes right to quality life, dignified life. So all these evolutions of the rights of the Constitution is due to bringing in due process under the fold of the Constitution. Now if you take United States, this word personal do not exist in the United States. It is complete liberty. Now the personal is added to restrict the word liberty. And the next is, another point is there that is called as property. But in India, that word property do not exist in the Article 21 of the Constitution. In the American Constitution, we have due process of law, but in India, we have procedure established by law. Now, in recently two cases, one is Maharashtra High Court judgment, and the other one is Supreme Court judgment. The Supreme Court judgment in Rajbala versus State of Haryana on reservations to on educational qualifications to the Panchayat elections, the Supreme Court departed away itself from the due process of law, and it clearly stated that the due process of law is not part of the Indian Constitution. On the other hand, the Maharashtra High Court, the Mumbai High Court in the case of Sheikh Jahid Mukhtar, in this particular case, it has upheld the due process of law, and with regard to the meat bans, etc., it has lifted the restrictions and liberally interpreted it. According to it, Article 21 consists of right to privacy. So the right to consume food within my four walls is part of my right to privacy. So that's why. So that by this elaboration of the Article 21, it has given greater credence, greater importance to the due process of law. Now coming to the Insure Farmers Against Climate Change. This is Firoz Gandhi's article. Now in this case, Indian is more prone for the climate change disasters. So there is an index for this that is called Climate Change Vulnerability Index. So in this Climate Change Vulnerability Index, we have India placed again in the highest vulnerable nation. So what are the things happening over here? If you clearly observe, the drought is increasing, erratic monsoons are increasing, and distress migration is increasing. The productivity of the soil is decreasing. All these changes, in these circumstances, what has to be done? So he suggests that insurance shall be given to the farmers with regard to the climate change and decrease returns on the climate change. For that, agriculture credit risk fund has to be established. And the remaining other points, weather-based warning systems, and next research on climate change, all these things are the traditional points. There is nothing new added over here. But the core of the point is to have the agricultural credit risk fund to be established. Now coming to the disinvestment, not privatization. So what this article tries to talk about is the Ministry of Disinvestment now is changed to the Ministry of Investment and Asset Management. So the privatization means there shall be a change in the management. Now with the existing disinvestment, there is no change in the management. Government still holds the control over the public sector enterprises. That is one thing. And the second thing is, coming to disinvestment. Disinvestment is all about shedding the shares of a company. It may to be a private player or common citizens through the stock exchanges. So the government is shedding the shares of companies by listing them in the stock exchanges. Third thing is, there is something called buyback of the shares. What does that mean? Government has 50% of the shares, let's take in a company. And the company such as Hindustan Aeronautics Limited, it has some 40,000 crores of the reserve money with it. So government is the owner of this share, and government is selling that shares to a government company. So it means now government shares come down to 40%. HAL itself becomes the owner of this share by another 10%. So the 40,000 crores of money which is unused in this company's account will come to the government, which can keep it kept for the productive use. This is what is the new technique the government is following. Now existing disinvestment, with regard to Hindustan Zinc Limited, the Supreme Court has given a judgment that any loss of the managerial control on the public sector enterprises established by law of the parliament has to happen only through the law of the parliament but not through the executive action. So that's why there is some some inactiveness with regard to the disinvestment process. Now coming to the lessons from Uttarakhand. Now there are two major questions comes up over here. One is, to what extent judiciary can involve with regard to the legislative affairs? That is the first question. The second, Article 356 misuse is decreased, but the misuse of the anti-defection law has also increased. And in this case, the Speaker has disqualified the members of the Congress dissatisfiers. So, after disqualifications, Rawat has won the election, won the floor test, what I mean is. So, in this case, what is the right of the Speaker to disqualify these members? Does the Speaker has to have the control over the defection law or the disqualification of the defectors? So this is what is the question. From the long it has been said, this control shall be shifted away from the Speaker to the Election Commission of India. And next is judiciary hand-holding in the entire process. It questions the role the legislature has to play. Especially there is a division of separation of powers between executive, legislature and judiciary. So in this context, the legislature and the Speaker's office getting directed by the judiciary, is it not judicial overreach is the question. Now coming to taxation. If you define the nationalism by various symbolic characters, how about increasing income in the country and decreasing the tax, decreasing number of taxpayers, or there is no proportional increase in the taxpayers to the growth of the economy? So in this context, let us understand it this way. If you take this year 2012-13, around 18,000 people had income greater than 1 crore of rupees. Now, the cars which are sold, luxury cars of 40 lakhs are more than 25,000. It shows that there is under-reporting of the taxes or tax evasion. So, not paying the taxes or tax avoidance, is that not against to the nationalism, is the question posed by this article. So, these are the articles for today. So, today and tomorrow I am a bit preoccupied with the students. So, that's why my videos may get delayed. And I will also give you the notes after a day. So, sorry for the inconvenience and thank you very much.